All right, I will go ahead and call the next case on the docket. Counsel, just to make sure you can both hear me. Is that correct?
I can, thank you.
Yes.
The next case is a workers' compensation case. It is number 122-934, entitled Patrick O'Neill versus the City of Hutchinson. And who do we have here for the appellant?
Good morning, Your Honor. Bill Townsley appears for the appellant, City of Hutchinson.
And for the appellee?
Melinda Young on behalf of the appellee and claimant Patrick O'Neill.
Just to repeat some preliminary remarks, counsel, I remind you that we have read your briefs, so we're familiar with the facts of your case and what the issues are. The appellant's attorney should let us know if you wish to reserve any time for rebuttal. And at the conclusion of the argument, we will take your case under advisement and we'll get a written decision out to you and your clients just as soon as we can. So Mr. Townsley, we'll begin with you. Do you wish to reserve any time for rebuttal?
I do, thank you, Judge. I'd like to reserve 3 minutes, please.
That is granted, and you can go ahead and begin.
Thank you. May it please the court. Again, I'm Bill Townsley, and I represent the respondent in the workers' compensation claim and the appellant herein, the City of Hutchinson. This is an appeal of a workers' compensation case. It comes to the court on 3 issues, but there's one issue that's determinative of the case, and that's res judicata or claim preclusion. This case is on appeal from the Workers' Compensation Appeals Board. Our position is the board erred in failing to identify the res judicata because it used the wrong standard. We contend also that the claimant failed to provide notice of the accident pursuant to the statute as required for a repetitive trauma claim. And then finally, our position is that the board erred in failing to deny the claim based on claimant's failure to sustain his burden to prove a repetitive trauma claim as defined in KSA 44-508. This is a de novo review by the court. It deals with statutory interpretation. And to the extent that the appeals board used the wrong standard for determination of claim preclusion, then we would contend that's an arbitrary and capricious error as well. The facts I'll deal with briefly, and again, I understand the court's familiar. Claimant was a firefighter who worked for the City of Hutchinson. He started in 1994. At age 29, he began receiving surveillance testing. Surveillance testing means they gave him ear exams for hearing loss. He revealed in 2002 that he had a hearing loss. There was no information that dealt with causation as pertained to that loss. Significantly as well, that loss never changed over the next 14 years. In 2009, he claimed a work-related accident, an accidental injury as described by statute. When he walked in front of a fire engine and a siren went off 3 times, he claimed a hearing loss. He filed a report of accident. He sought no medical care. In 2010, he saw a physician who told him he had an occupational hearing loss. Claimant did nothing further at that time, but pursued his accidental trauma claim. It proceeded to hearing finally in March of 2016. It was the one claim only. It was not a claim encompassing a repetitive trauma. Traditionally in workers' compensation, alternative claims of theories are pled with regularity, whether it's a back injury claim, a hearing loss claim, a carpal tunnel claim. In many cases, the claimant's lawyer will plead an accidental trauma, an accidental occurrence, as well as an each and every day occurrence, meaning a repetitive trauma claim. That's common in workers' compensation. It did not happen here. That's significant for this case. The case proceeded on to an award by the administrative law judge in 2016. The board reversed and denied the claim in 2017. The significant portion here is that in July of 2016, after the close of evidence, the plaintiff filed a repetitive trauma claim for the exact same hearing loss. After the first claim was denied and reversed by the board, the claimant then proceeded to a regular hearing in March of 2018. Significantly, claimant presented no new evidence of the claim regarding the claim, the second claim for repetitive trauma. The same administrative law judge issued the same award he did previously. It went to the board, who reversed the administrative law judge, but found an award for future medical based on the discredited physician that plaintiff used in the first hearing, Dr. Biaria. The board applied the wrong standard for determination of res judicata. So the three issues we have on appeal, as briefed, are whether the board erred in failing to identify res judicata, whether the claimant failed to provide notice, and whether the claimant failed to sustain his burden for establishing a repetitive trauma claim. Again, we believe the res judicata is the significant issue. And again, claim preclusion deals just with that, precluding claims that have been already litigated. In page 6 of the board's order, it sets out the elements for claim preclusion, but these are elements as defined in federal law. And this is one of those unique areas where Kansas and the federal government or the federal judiciary have identified different elements for the same claim. In the federal standard is you have a final judgment, you have the same parties, and you have the same claim. In Kansas, we have the same claim, the same parties. It includes claims that were or could have been raised, and that's the significant factor here. And then finally, a final judgment. Here we have all four of those things. Both claims concern a hearing loss, no matter whether the claimant and the appeals board have conflated the term of claim preclusion to be cause of action, meaning theory of recovery. We have a hearing loss claim, both the accidental occurrence and the repetitive trauma, they're hearing loss claims. So notwithstanding the wrong standard, the board still erred in trying to define this claim.
Counsel, we have a question.
Mr.
Yes.
Chairman, I can ask you a question if I might. I want to drill down a little bit. Can you hear me okay? I'm sitting a little bit away from the mic.
It's light, but go ahead, Judge.
I want to drill down a little bit on this res judicata previous claim, and I guess I want to get your answer, Mr. Townsley, on if the claimant here had done as you suggested kind of in your argument about amended his claim to include this repetitive injury theory, would that change your argument on res judicata? Would that eliminate that as an issue if that had been done here?
Well, it would have, Judge, because it would have then been litigated in the first claim. And I think that's what the dissenting board member said. And I'll note that was the board member who's a practitioner as opposed to a long-term administrator or judge. He pointed out that that's routine in workers' compensation to have alternative theories presented. And his position is that the claimant should have done just that, should have amended the initial claim. And again, there was the indicia was plentiful that there was a repetitive trauma claim pending this entire time, but it wasn't alleged. And again, we believe the board has misconstrued what a claim is for claim preclusion. It's simple here. These are both hearing loss claims. In what could have been litigated in the first claim were both a repetitive trauma and an accidental occurrence. Again, that happens all of the time. For whatever reason, that wasn't asserted here, and it's laughable to say that, gee, we didn't know about this until July of 2016 when Dr. Epp testified. In fact, the claimant's testimony and Dr. Bieri's testimony deal with these issues. So again, for our position is the board erred on the res judicata issue, and clearly they misidentified the standard for claim preclusion in Kansas by omitting that critical third element of all claims that could have or should have been litigated. That's missing completely from claimant's appellee's brief. It's missing from the board. How they have misidentified the Kansas standard is mystifying. But if you apply the Kansas standard, res judicata should have been applied here. And that's our position. That's what we asked the court to do here. I'll address the notice issue briefly. Here, again, the statutory requirement for notice in a repetitive trauma claim sets out four potentials. Two of them might apply here. One is on number 3, and this is 44508. The date the employee, while employed for the employer against whom benefits are sought, is advised by the physician that condition is work-related. That happened by claimant's testimony and Dr. Bieri's testimony in 2010 when he saw Dr. Smith. That should be the date of notice, or that should institute the timeline for providing notice to the insured. It didn't. The board erred here by saying, gee, we have this surveillance testing that started in 2002 when he's 29. It continued at 2-year intervals till he turns 40, and it's yearly afterwards. That testing never changed, and significantly, and Dr. Epp testified about this, there's nothing about causation here. All this showed the city was this is a gentleman with a condition. We raised in cross-examination the many factors that could have caused that condition: congenital issues, mowing, his history with firearms, fireworks, all the things that we normally see in a day-to-day living. Significantly here, the claimant filled out one of these forms and said, gee, I had a hearing loss in high school. So again, a surveillance testing provides no information regarding causation. It simply identifies condition. Here, if claimant's condition had worsened over the years, then there would be an indicia that perhaps his work-related activities were causing that condition. That didn't happen here. Again, his condition was stable, and there's no evidence whatsoever regarding causation that comes out of surveillance testing in this case. So the board erred in determining that notice was supplied because of the city's awareness of a hearing loss. Again, there is no evidence regarding causation. Our final issue is that the claimant failed to sustain their burden regarding compensability. And again, this is statutorily driven in 44508 again, in any repetitive trauma claim. And the statute reads, repetitive trauma refers to cases where an injury occurs as a result of repetitive use, cumulative traumas, or microtraumas. The repetitive nature of the injury must be demonstrated, and this must be demonstrated by diagnostic or clinical test. That didn't occur here. There's no evidence of any repetitive injury based on diagnostic or clinical test. The statute says the repetitive trauma must be the prevailing factor in causing the injury. Again, there is no testimony whatsoever regarding prevailing factor here. So again, this is a case that involves...
Counsel, we have a question.
Yes.
Mr. Townsley, what are we supposed to do with, didn't the city take the position in the initial case in the accident case that this was a repetitive injury?
We did not take that position, Judge. We made that argument in conjunction with the fact that he had pre-existing issues arising out of the acts of daily living. Again, the things we identified in cross-examination were congenital conditions, lifetime activities with firearms, lifetime activities with mowing and chainsaws, and the medical treatment that he used, the pharmacological result from some of the certain medications that he takes. We also argued that his work activities would cause that. And again, that should have been notice, that should have caused claimant's counsel to amend the petition, because Dr. Bieri in his deposition says, heck yes, these are chronic conditions. Half the people I see, this is a chronic condition. So again, why the claimant didn't plead alternative theories when that's commonplace, we don't understand.
I thought that Dr. Epps' testimony was that this was a repetitive exposure injury from work, and that's what prompted the claimant here to, in essence, add this additional claim even before the first case was resolved, that while that case was still going through, once they had the benefit of your expert's testimony, they then added this new claim. So it seems like there is evidence there, and that's what they based was your own expert's opinion.
Well, and to clarify that, Judge, that's not quite right. Bear in mind that the claimant's testimony was, I had no problems prior to 2009 when the traumatic injury. He testified, I had no prior problems. I had no hearing loss. He told Dr. Bieri, gee, I didn't have any of the tinnitus prior to 2009. In other words, as he testified in the initial case, I had no issues before 2009 was his consistent testimony. In his reports, his history to Dr. Bieri and Dr. Epp were exactly that. I had no prior problems. So Dr. Epp's offhanded comment was, gee, given his history of not having any prior issues, then this is probably an occupational noise exposure. Again, that was based on the limited information provided by the claimant, which was wrong, and an offhanded comment that didn't respond and was not set forth with a reasonable degree of medical probability and without any opinion regarding prevailing factor. That was a comment that was made, and sure, claimant presented, then filed that application, but evidence was closed at that point. So the decision hadn't been issued, but there was no further evidence. We were past our terminal dates. The case was submitted. So
Counsel, you've used up your rebuttal time, but I'm still going to give you 3 minutes of rebuttal.
All right. Thank you, Judge. I appreciate that.
And Ms. Young will turn to you, and I'll allow you up to 18 minutes if you want it, just to make sure you both get the same amount of time.
Thank you. May it please the court, Melinda Young on behalf of the appellee claimant Patrick O'Neill. I'd like to focus my argument on the res judicata issue. I know that the appellant is concerned or is critical of the appellee's statement regarding the law on this issue and the three elements that appellant claims is actually 4 in order to prove res judicata. Essentially, we're talking about the same thing. The law cited is clear, and the issue here is simply whether kind of 2 areas. One is, clearly we have the same parties, so whether there was a judgment on the merits in the earlier action, which we do not have. We have no final judgment on that original specific event claim. If we did, we'd have a very different situation on our hands. And so the other issue is whether we have the same cause of action, and we don't. The first cause of action was for a specific event, permanent impairment flowing from that specific event. The second claim is a repetitive injury claim. And I just want to correct that the appellant argues that there was no new evidence presented in the second case, and that is just not true. There was testimony from Dr. Epp about his opinions on the repetitive injury claim, as well as testimony from the claimant regarding his employment and his noise exposure over the long course of his employment. But appellants most critical of the claimants or argues most strenuously that the repetitive injury claim could have and therefore should have been brought at the time of the initial specific event claim. However, that is just not the case because there was no evidence of a repetitive injury claim, no evidence to support such a claim at the time the specific event claim was pled, and all the way through the those proceedings up and until Dr. Epps' testimony, the appellant's expert, until he testified that this injury and impairment was a result or caused by repetitive exposure. Counsel mentioned that, alternative theories are pled in workers' compensation cases with regularity, which I agree is true, but there are also in the world of workers' compensation multiple but separate claims filed involving the same parties and separate claims for injury. The claimant here made his claim for injury from the repetitive trauma, repetitive noise exposure, as soon as there was evidence that the condition was caused by repetitive trauma. Prior to Dr. Epps' testimony in this first claim, the claimant was relying on the testimony of Dr. Bieri that the claimant's permanent hearing loss was a result of this specific work accident on February 23rd of 2009. Dr. Epps' testimony occurred after the regular hearing in that specific event case was held, after Dr. Bieri's testimony was concluded, and just right at the end of the terminal dates in that specific incident claim. So that testimony from Dr. Epp is what triggered the existence of a repetitive injury claim. And, counsel argues that the claimant should have pled this alternative theory, that, we should have included, we have a specific event of hearing loss, we should have included a repetitive injury claim. And I believe that doing so could actually be malpractice to do so without evidence of a repetitive injury, because a repetitive injury does not become compensable until there is a diagnosis of a repetitive injury that is conveyed to the claimant. That is in the statute at KSA 44508E3. So to claim a repetitive injury claim or to make a repetitive injury claim before any diagnosis of a repetitive injury condition would result in a ruling that an injury, a specific event injury, was not a result of a repetitive injury, which would preclude any future repetitive diagnosis. So the claimant really had to proceed with the claim that was supported by evidence. And once there was evidence of the repetitive injury claim, that's when claimant.
Counsel, we have a question.
Yes.
May I ask you another question? Is it your position to the court that you couldn't have amended your initial claim once you got Dr. Epps' testimony? You couldn't have gone in and amended your claim. The only procedural avenue open to you was to do what you did, to file basically an additional claim. Is that what you're telling us?
Yes, given the status of that claim. If we had been, early on. I'm sorry, I can't tell if I'm interrupting you. I'm not trying to interrupt you.
Go ahead. Go ahead.
Yeah, if we had been before early on in the claim and before evidence was submitted, and certainly before evidence was closed, then claimant would have been in a position potentially to amend the claim and add the repetitive injury claim to the initial claim, but we weren't. I mean, that would be, it seems to me, akin to trying to amend a pretrial order in a civil case after the submission of all the evidence, and after the, all the rulings in the case have been entered. So there is no preclusion or no statute precluding the claimant from making a second or multiple workers' compensation claims against the same employer. It all depends on the evidence that exists and what supports those claims. So because of that, because of where we were in the proceedings, the only option available to the claimant at that point was a separate claim. That was based on the employer's evidence that the claimant had suffered a repetitive injury.
Thank you.
Yes, thank you. And the other issues with the other arguments of the notice, I think that unless there are any questions, I feel that is straightforward and set out in the parties' briefs. That the bottom line on the timely notice is, again, the workers' compensation statute identifies when a repetitive injury claim exists, which was at the time of Dr. Epps' testimony, and a claim was made within the permitted time allowed. And even if for some reason there's an argument that it wasn't, the respondent making this argument of this is not a specific event, this claimant has had repetitive noise exposure, was certainly, and their own expert having this opinion was certainly on notice of the repetitive injury, and now can't claim that they didn't have timely notice. So unless there are any other questions for me, that is all the argument I have today.
Hearing no questions, Mr. Townsley, you still have your 3 minutes of rebuttal.
Thank you, Judge. Let me say at the outset, I appreciate the extra 3 minutes. I know when I've argued to the Supreme Court, we have a timer that's given me that time. I appreciate this is your first day back in the courtroom, and I think that's great. 3 microphones might be better in the future, but so much for my technical commentary today. Again, the issues here I think are pretty straightforward, and I'll respond specifically regarding res judicata. What I heard Ms. Young say is that, well, we're talking about the same thing, whether it's 3 elements or 4 elements. Well, that's wrong. And what she passed over again was, and what she actually said is, gee, we're arguing that you could have or you should have made the argument. Well, yeah, that's exactly the point here, and that's what Kansas law says. I'm looking at Kane v. Jaycox, head note number 3. Before the doctrine of res judicata will bar a successive suit, 4 elements must be met. Number C, claims that were or could have been raised. Again, it's standard in workers' compensation to have alternative theories. This case fit within that. And let me just turn to the testimony of the claimant in March of 2016. On direct examination, he says, gee, I've never had any issues with hearing. No ear disease, no ear surgery, no hearing loss before the incident. Then on cross-examination, I asked him, what's true? You've had issues with hearing before this accident. True? He says, at that time, I'd already been a firefighter. There may have been some other diminishment in hearing, but specifically what it wasn't until about that time in my career that somebody was saying this is starting to really show up as a problem. So I asked, when you say you've been a firefighter for a long time, what do you mean? Are you exposed to noises in the course of employment that would affect your hearing? His answer, constantly. The question again, when we're here just to discuss this one incident of February 23rd, 2009, true? Are there other incidents that have occurred? Answer, oh, sure there are, all the time. I mean, they're things that are part of just going through the normal part of being a fireman, and there are things that are not normal. At any rate, this is discussed in his regular hearing, and we are put him on notice, hey, these are issues. And Judge Powell, to your question, absolutely, this case could have been amended. There wasn't a decision. Our evidence was closed, but that happens just in a civil case, as pretrial orders can be amended to serve the better interests of justice. The bottom line in this case is we're asking you to reverse the appeals board. The appeals board decided the issue of res judicata incorrectly. It used the wrong standard. Res judicata is a common law rule of equity grounded in notions of justice and in sound public policy, each of which demands that a party not be vexed with litigation twice for the same cause. This is the same cause. These are a hearing loss claim. They should have been litigated. They weren't. Res judicata applies. So we ask you to reverse the board. Thank you very much.
All right, counsel, thank you very much for your briefs and your arguments. We will get a written decision out to you and your clients just as soon as we can. And with that, this hearing